Harlen here. He's a member of the local ISSA Kentuckiana chapter, and he's submitted a great talk here that we selected as a keynote. So hopefully you all will enjoy. And I just want to hand it over to Harlen and thank him for submitting and accepting as a keynote. So thank you all, and thanks, Harlen.
Yeah, and thanks again to the... All right, I'm going to try to not move that. Thanks to the Kentuckiana chapter of the ISSA for a fantastic conference. I understand that all that is standing between all of you and closing ceremonies is this talk. Brevity is a virtue. It's not one of mine, however, so I'll do the best I can. This is I guess I should introduce myself first. My name is Harlen Compton. For those of you who haven't had the pleasure of meeting, I can usually be found loitering around the ISSA chapter meetings on the first Friday. They feed me. I show up. I am a bit of an oddball professionally. I had a really good thing going as a software developer in the cybersecurity space. I worked in finance, healthcare, a little bit of time with the Department of Defense, and I don't know why I decided to screw that up and go to law school. It's so long ago, it's blacked out of my memory, but I did. So I thought that would make me, beloved among attorneys and engineers. It turns out I just no longer fit in with either group. But I am an effective translator between the two. And so what this talk is about is taking a look at the bigger picture of how compliance works in an organization versus cybersecurity. Some of this is background material, especially for you compliance professionals in the room. I did this talk a few months ago for a bunch of lawyers talking about engineering, and so now I'm trying to do it the other way around. So we'll see how it goes. And right into it. So first thing is the old security versus compliance debate. Everybody's familiar with it, right? Everybody familiar with checkbox security, where your legal department sends you those questionnaires or whatever it is your organization does. And it's like, you have to do these things, and if you do these things, we're going to tell everybody we're secure. And that's in no way true, but that's just how it was. It still is today, but I'm going to get into why it's not even that simple anymore. So if you came here looking for a checklist of things I can do to keep my organization out of legal trouble, you may have come to the wrong place. But again, we'll see. Today, we go back and forth between security and compliance departments. They want us to do the checkbox things that don't matter. We want to actually protect data so we don't have a breach and don't have to worry about it. And nobody has figured this puzzle out. Even Microsoft, who love them or hate them, you'd have to agree they've got their stuff together when it comes to regulatory compliance. Had an issue recently. I don't want to breach my NDA, but some of you use Azure. They do these audit reports. And I was reviewing their audit report, and they had a security finding. But when you go and you read it, they didn't actually have any security issue. It was a routine task that they're supposed to be performing, and they did, but somebody forgot to fill out the appropriate form and put it in the appropriate place. And so the auditor said, oh, you've got a security issue here. And so all over the country, I'm sure for the past 3 months, Microsoft's sales department has had to be having conference calls with legal departments for their enterprise customers because somebody didn't fill out the right form, even though they had proof they had achieved the control. So that was hard enough in a world where our companies were only bound by one regulatory scheme or one set of laws. Today, it's a little different. I use the term minefield because I couldn't think of anything else to call it. But I'll occasionally talk to somebody who thinks that their organization is immune from all of this data security stuff. I have yet to have such an encounter and have it end where I'm convinced that you're right, you're not under any of these regulatory frameworks. I suppose if you had a farm in Nebraska with no internet access and no employees and no health insurance benefits and no customers, maybe you wouldn't have to worry about any of this. For the rest of us, we do. We've got the big ones, and this slide is not comprehensive. There are so many things out there. I just went with the ones that I've worked with. But we're all familiar with the big ones, right? I work in healthcare at the moment with HIPAA. In the financial world, we've got Sarbanes-Oxley. And of course, everybody's favorite subject the past few years, the European Data Protection Act, or regulation, the GDPR. And of course, there's always been the voluntary, I put those in quotes for a reason, voluntary frameworks, right? PCI DSS, you don't have to deal with that if you don't want to handle credit cards. We're still a cash society, right? The AICPA has their standards. If you deal in finance, or if you remember SAS 70, now the SOC reports, that's usually required, depending on your line of business, by your customers. You know, there's FINRA. HITRUST is my new favorite one because my main client is going down that road. Then, of course, not to be content to let the feds and the Europeans steal all the fun. Various state regulations have been emerging over the past decade. The first one I encountered in my career was the Massachusetts data privacy laws. Ohio came around in 2018 with the Ohio Data Protection Act. There's the New York data law, which was interesting because it's an incentive in the healthcare space. And in the news lately, the California Consumer Privacy Act, which has passed. It's going to take effect on January 1st, and the entire legal community and the government of California is still unsure exactly where and how it's going to apply. It's interesting like that. And as the old adage goes, as goes California, so goes the rest of the country when it comes to regulatory regimes anyway. And so there's already a plethora of copycat CCPA regulations popping up in state legislatures all over the country. And not to be content to let the states have all the fun, the alphabet soup agencies that we all know and love each want their piece of the data security pie. So there's been a lot of big moves in the past few years from the Federal Trade Commission, the Securities and Exchange Commission to have their own set of criteria that you have to abide by. And of course, the state's attorney generals, we'll talk a little bit briefly about Equifax in a moment. They've realized there's money to be had from companies who have data breaches. And no talk about lawyers and regulations would be complete without plaintiffs' lawyers. Ambulance chasing is tiring. Why not just sit at home and wait on the breach databases to come to you? So the alphabet soup agencies, the first one I wanted to talk about was the Federal Trade Commission. FTC enforcements aren't new, right? The Federal Trade Commission's always had this standard against unfair or deceptive trade practices, and that's any business in the United States. They've been charging businesses with lax security practices who experience breaches with unfair, deceptive acts, and historically those have always been settled. We'll get to settlements in a moment, but basically through a thing called consent decrees, where a company says, I agree to admit that I did wrong and you have the authority to penalize me and here's some money. Until the Wyndham hotel chain came under the ire of the FTC. The FTC came in and said, hey, Wyndham, your data security is terrible. It's obvious that you just don't care. Your customers' data is leaking everywhere, and we're going to fine you for unfair business practices. But Wyndham, instead of rolling over like everyone else prior to then had done, decided, no, we're going to go to court because FTC, I don't think you have the authority to even meddle in this. Long story short, Wyndham claimed that the reason that they didn't have the authority was because he never gave them notice. Notice is an important legal buzz phrase I'll go into more later as well. Of what appropriate safeguards are. Like, hey, there's no HIPAA, there's no, matrix of controls for me to check off and make sure that I've done what I'm supposed to do. And the court found that those consent decrees are all public. They're on the FTC website, and they constitute sufficient notice, and that you as companies should read them and make sure that you comply with them so you don't have to pay the same fines. The main thing I want to highlight here, and my bold print is much more stark on my high definition screen than it is on the projector. but I've highlighted the phrase reasonable here, and you'll see this coming up over and over and over again. But I'll save that for now. So the question is, if a federal agency can penalize us for not abiding by standards that they haven't listed anywhere, just a body of precedent saying these are things other people have got in trouble for, so don't do those, where does that leave us? And I posed this question to the lawyers I was talking to. Nobody really has an answer. We're still waiting for courts to churn out some more lawsuits to answer that for us. The Securities and Exchange Commission is another favorite of mine. They've been bringing enforcement actions under Regulation SP for at least the past 10 years, probably longer. I haven't been an attorney that long. I was licensed in 2014, so anything before that is history to me. In 2016, there was a landmark settlement against Morgan Stanley for $1 million. That was an issue where one of their employees had been exfiltrating data, and that employee shouldn't have even had access to the data. It wasn't like they used some crafty exploit kit. They didn't go to one of Jeremy Druin's classes and learn some cool trick and steal data. They just copied it from the share and walked out with it. Regulation SP requires that companies have, here's that word again, reasonably designed policies and procedures to protect consumer information. The SEC continues to go down this road because if you know much about government, once they've got a taste for money and that they can get money out of us, they just keep going. So they created a cyber unit for enforcement in 2017, and I was just reading about another one this morning. And then my old friends, the plaintiffs' lawyers, the ambulance chasers, the ones you see in the cartoons, not to be left out of the money pie that exists for lawyers after a data breach. There were 23 private, so these aren't government entities, these are like consumers who banded together and tried to start class action lawsuits. There were 23 of them filed in the week that followed publication of the big Equifax breach with which we're all familiar. There ended up being 50-something, if I recall correctly, by the time all was said and done. And better than that, for the first time, it may be the only time this has ever happened, all 50 state attorneys general joined together in a private class action lawsuit against Equifax. And if you're not familiar with what happened with Equifax, everybody knows about the basic control you have in place about patching your software. And then they didn't do that for a couple months. There's a big Apache exploit, and that's how the whole thing happened. It's always the simple failures that make the big breaches. Now, with this patchwork of things that I just described, and that's not even a tenth of it, I could do an entire hour-long talk just on all of these different frameworks and regimes. But what happens to us? Because there's so many that we don't have one set of standards to follow anymore. One example I like to bring up is if you are a health entity that does business in Europe. Now you're kind of in a damned if you do, damned if you don't situation in some ways. So if you're familiar with the GDPR, one of the things it has, the press likes to call the right to be forgotten. It's the right of erasure. It's that me as a consumer, if I were a European subject, which I am not, have the right to talk to any company who is holding my data and tell them to delete it. And that would include healthcare entities. But in the United States, patients don't have that kind of right under HIPAA. In fact, it's exactly the opposite. HIPAA, while being about privacy, is also about complete records and the insurance part, the I. The I is important because you can't just call in and say, hey, delete my records. Otherwise, myself as the chronic smoker, obese guy who never runs that I am, would love to call every healthcare provider I've ever had and said, hey, delete my data and watch my insurance rates go down. Meanwhile, all of you healthy folks get to make up the difference. In the United States, that's not allowed for a very good reason. So what do you do if you have a European citizen who lives here and is treated here? What about data concerning individuals who aren't the patient? So under HIPAA, you can't even talk about data to somebody who's not the patient, but patient records have things like paternity information, bereavement and emergency contacts. Genetic information. Anybody ever been to see their doctor and you have to fill out that form about did your mom or dad have heart problems or diabetes or whatever? Well, that's private information about your mom and dad. They don't have any say over that in your medical record. It's your record. These are unanswered questions. I'm just illustrating the kind of crossfire that we're caught in. And then, of course, just the standards for enforcement are different. The GDPR has very rigorous standards about, it's very black and white. You did it or you didn't. HIPAA has this more nuanced approach of it's okay if you screwed up as long as nothing bad happened, right? No harm, no foul. That's a terrible way of putting that, and don't ever tell anyone a lawyer said that. All right, the Ohio's Data Protection Act is another example of where these things are going in different directions. Ohio decided to take a different approach and looked at the United States and said, companies are getting beat down all over the place because of data security and data breaches. Maybe instead of using the stick and beating them down some more, we as the state legislature should take a encouraging approach. So what Ohio did was they created their data security law and created, the press has called this a safe harbor provision, where if you get out of jail free card, if you've done these things, then you can't be sued in court. What actually they created is called an affirmative defense, which means it doesn't stop you from being sued. It's something that your lawyers can raise in the lawsuits. So if you're worried about paying the expenses of litigation, Ohio doesn't help you there. Nonetheless, it's a nice thing to have. And all you have to do to qualify for that is to substantially comply, reasonably, back to that word, that's going to keep popping up. Reasonably conform to one of a list of frameworks. And that list of frameworks includes NIST and High Trust and I think CIS. There's a few of them. And so if you can show in a court of law when you're being sued that you reasonably conformed with one of those frameworks, then that's a defense to someone's claim that you breached their data. Meanwhile, California headed exactly in the opposite direction. The California Privacy Act introduced for the first time a defined private right of action, which means that you or I, if we lived in California, have a right to sue as individuals companies who lose control of our data. That's not actually a remedy that's available to us in the rest of the country or in California until January 1st. And normally when we want to sue a company, we go into a big class action and we allege that they've harmed us in some way or that they were engaging in unfair practices. California will be the first place where you can say, you lost control of my data, that is my legal claim, not some other thing, and we'll get into some of those other things. But what happens, does anybody here do business just in Kentucky or Indiana, one state? That's really cool, and you are so lucky. For the rest of us, our companies are growing. We have customers all over the country, and it's very realistic that if we experience a data breach, that we're going to have customers in Ohio, in California. Our business might be in Ohio or California. And what happens when we start getting sued under that new right of action I just talked about, under the CCPA, and we raise the Ohio affirmative defense because our business is in Ohio, what's court going to do with that? Again, we don't know until somebody gets sued and we find out what happens. All of that is to try, anyway, to paint a picture of this patchwork landscape, the minefield. So I want to get more into the legal side and talk about how does all this work? So all day at this conference, we've talked about preventing breaches, detecting breaches, good security practices, etc. So what I want to talk about is what happens after the breach. That's something that we tend to not think about too much as security professionals. But what happens after the breach, when you start getting into these lawsuits in the court system, that circles back, and that's what creates the foundation for how we argue for the controls we put in place and how we justify spending money on them. So if you're struggling with your board of directors or management or whoever it is that signs the checks in your organization, especially if it involves the legal department or your compliance people, this will be some valuable stuff to know. You can speak a little bit of their language and bolster your case. So to start with, we all know that data breaches are expensive. You've all seen charts like this with the $4 million, $3.92 million, the average cost of a data breach last year. We all know that the United States experiences the highest burden of that cost, and that the healthcare industry has finally overtaken the financial industry as the bearers of the largest cost of data breaches. Everybody agree that it's expensive when you have a data breach, so I don't really need to go on much about that. But where do those costs come from, right? So when I was working in security, security proper, before I went to the dark side, I never really thought much about this. I just knew it was expensive, right? You know, if you have a breach, it's going to cost this much money. But why? Is there like a data breach fairy that walks into the CEO's office with their hand out and say, give me $4 million? It doesn't quite happen that way. There's a lot of costs that come with a data breach, right? You've got your classic loss of reputation, business opportunities. Anybody signing up for a Yahoo email account lately? Your ability to contract. So if you deal with Sarbanes-Oxley, you deal with anything under Homeland Security, if your customers require you to have those SOC reports, you experience a data breach, you may be ineligible to keep doing business in your sector. Insurance coverage is a cost that seldom gets thought about, but your insurance company, if your company has a cyber insurance policy, which it should, and if it doesn't, maybe look into one. In the fine print of that policy, there's a list of data security requirements for your organization for this policy to pay out. And if you try to file a claim, they're going to come find out if you complied with those terms because they want to deny your claim. That's what insurance companies exist for, is to not pay you money. You have your loss of certification. There's breach of contract issues. I know with my company, the contracts we have with our customers have all kinds of liquidated damages clauses, etc. There's the classic fines, injunctions, and sanctions that we're all familiar with. Civil suit damages, so those plaintiffs' lawyers, the attorneys general coming in with private lawsuits. And then, you know, I'm throwing cost of notifications. I work a lot with HIPAA, and that's by far the biggest cost when there's a data mishap, is you've got to notify all these patients. And then my personal favorite is the attorney's fees and litigation expenses. The only person who wins in a data breach is your company's chief legal officer and whoever they hire. So that last one is the thing that everybody's afraid of, and why you so rarely hear about the rest of what I'm going to get into, because companies are driven to settlement because they're scared of the cost of litigation. Settlements are a shortcut I'm not going to assume that everybody here is familiar with the way that the lawsuits work, but I sue you, I say you breach my data, and you look at your attorney and say, how much is this going to cost to defend? What are the odds that I'm going to win versus what am I going to lose? What's it going to cost if I win? All of that goes into this actuarial calculation to determine, I'm willing to settle, I'll write a check for X dollars and you go away. And I'd say 99% of the time, that's how these things end. And a lot of it has to do with, again, the fear of those costs. But it's important to put those aside and let's just keep stepping forward in what would happen if you are sued. So let's say that your organization is sued under one of those rights of action under the CCPA, or the FTC comes after you and you fight back like Wyndham did. In the law, we have a phrase where we say a cause of action sounds in some area of law. Right? There's different areas of law. There's contract law. There's property law, which I've kind of ignored for this whole thing. But you know, if you violated someone's patent or trespassed some other way, that would be a different area. There's the statutory items where a government body comes after you and says you violated the law in some way. It's not like a traffic ticket where they just get to write you a citation, right? They got to go to court, they got to prove it unless you settle with them. There's civil actions in state and federal court, and the one that I'm going to spend the most amount of time on, because it's the one that happens the most often in cybersecurity, is torts. And if you've never heard that phrase before, think back to the ambulance chasers. A tort is an injury of some kind. So I was in a car accident, and now I've sustained these medical bills, and my car needs replacing, and I'm out of work, and you, as the person who caused it, I'm taking to court, and you need to make me whole. Or, you know, all the claims you've heard about infliction of emotional distress. The infamous McDonald's coffee case, which, if you want to know more about that, that never actually happened the way it was played up in the media. I'm happy to talk after this. It's one of my favorite subjects. But those are all torts. The California right of action will also, if you were to sue somebody under it, you would be suing them in tort. Now, your organizations and my clients, they don't care what way the lawsuit sounds in. I'm bringing this up because it's important for where we're going. They just don't want to be sued. There's also the concept of proof. So what happens when somebody sues you if you don't settle? The first thing your staff does, or your legal staff do, is they file a motion to dismiss. They say, hey, Your Honor, you know, even if you assumed everything that the person filing this lawsuit said is true, it still doesn't meet the legal requirements of proof, and you should dismiss the case. If that fails, the suit goes on, and you start going into what's called discovery. Everybody's heard the phrase e-discovery, and why is it so expensive? That's the process by which companies or just litigants in a lawsuit get the right to inspect the records and personnel of whoever they're suing or being sued by to collect evidence. The purpose of all of that evidence is so that you can have proof in court. Eventually, these things go to a trial, presided over by a judge, and you have to put on proof. You don't just get to say, hey, this happened, and everybody knows it. You have to do this formal process. So back to Microsoft at the beginning when the auditor cited them because they were missing a form. Well, the form is the proof. So even though everybody knows that they actually carried out that control just fine, they couldn't prove it in the legal sense. There are different standards of proof. This may be a review back to high school civics, but I never learned this in high school. In fact, I heard these phrases for the first time as a law student. So prima facie evidence is what I just talked about, that, hey, there's enough here to sustain a lawsuit that a judge is going to let you go ahead and go to trial. If you don't have that, like you've just got no proof, like, hey, I think they lost my data and they're responsible, but that's it, you're not going to get anywhere. Preponderance of the evidence, this is the one that you're most likely to deal with. This is the standard of proof in every civil action. And it says, are you more likely than not to have proven whatever it is you're trying to prove? I like to call it the 51% threshold, which is not to be confused with the beyond a reasonable doubt standard that those of us who are law and order junkies are familiar with, where if you can just create some level of doubt, your client gets to walk. Civil suits don't work that way. There might be a lot of doubt that you're actually responsible, but there has to be at least a majority. And then there's the question of who has to prove. So almost all the time, technically, it's the person who is doing the suing who has the burden of making their case. So you, as an organization who experienced a data breach, if you've ever lived through one of these before, the first thing that your legal department does when they show up is they tell everybody to shut up, turn their email off, and don't say anything to anybody. And that's not just because they're control freaks and narcissists. We are. But it's also because your company, who's the one being sued, doesn't have the burden to prove anything. And so the Fifth Amendment in criminal trials is the same concept. Like, don't say anything. Let's see what they have and go from there. But there's exceptions. For instance, the Ohio Act that we talked about a little bit ago, if you were trying to raise that affirmative defense saying, hey, I'm immune from this lawsuit because I complied with Ohio's requirements, well, you as the defendant are the one that have to prove that. So you don't just get to say that. You've got to come to court with your proof. And if the fact finder, which is another thing I'll get to in a moment, believes you, then you're good to go. But let's be real. This is where I take off the lawyer hat and put on the pragmatist hat. Juries aren't composed of attorneys. Juries are composed of folks like me and you. And the jury's going to say that there was clearly a data breach, and it was clearly your data. So what are we doing here? And so even though legally speaking and procedurally you don't have any burden of proof, you kind of do, right? You've got to convince the jury that you weren't responsible for this loss of data. The fact finder would be the jury in most cases. Sometimes it's just a judge. Their job is anytime the person who's suing you and you say, I disagree that this is the fact, well, those are what juries decide. There's a popular perception that juries just kind of sit down and say guilty or not guilty and move on. But that's not actually what lawyers are asking the jury to do. They're asking them to each one of these things that are in dispute, which side do you think is telling the truth? And then the sum of that, at the end, the math answers the question of guilty or not guilty, because that's already established in the law. Every case has required elements that must be proven, right? You don't just walk into court and say, you had crappy security and you breached my data and here's my wealth of evidence that your security was terrible, I win. There's actually a set of legal elements for every claim, and they're different for every claim depending on what you're suing under, that determine whether you're going to be successful in the end. We're going to focus on torts again because we don't have 6 hours for me to go on about this, and this is the most common one. So in a tort, as every first-year law student has beaten into their head until they're saying it in their sleep, you have duty, breach, causation, and damages. These are 4 pieces that you have to prove to a court before you can get money out of somebody for an injury. So in that California cause of action, somebody loses control of your data, you have to go and establish each one of these elements to the court. So question 1 is, let me think of which perspective I want to look at this from. We'll go from the plaintiff's perspective, the person doing the suing. So you have to prove that the person you're suing owed you some duty, right? Generally speaking, you and I don't owe each other anything other than, respect and civility, but everybody owes, under the law, a standard of care that's just, normal decency. After you prove that the person you're suing owed you some duty, you then have to prove that they breached that duty. So not only that, but you then have to prove that whatever harm you suffered was because they breached their duty, right? You can't say that you weren't rotating your passwords as often as NIST says, and also my data is out here on the dark web, so you're responsible. It doesn't work that way. You got to show that one thing caused the other. You have to prove that in a court. And then finally, and this one's always the fun one, this is the one that gets all the media headlines, is you have to prove what damages you suffered. So you can't just say you owe me $10 million. You have to put on evidence of why you sustained $10 million worth of harm. Unless there's a statute that says you're entitled to that, but again, brevity. So when we're talking about a breach and a duty, generally speaking, these are all going to revolve around the standard of reasonable care. Everybody remember seeing reasonable on a whole bunch of slides before now? Reasonable is a term of art amongst attorneys. Some of us love it, some of us hate it, but it is what it is. And the reason it's so prevalent is because it isn't very well defined. And so what you have to do is you have to go to previous court cases, see how they were resolved and how your case is similar, and that's how we build up the standard of what is reasonable. Technically speaking, reasonable is what would an ordinary person do or be expected to do. So it's not what would an IT whiz be expected to do, or what would your company who's really awful at security and doesn't care about it be expected to do. It's what would an ordinary person do. So ordinary in our cybersecurity world means industry standards, right? Those basic core controls that every one of those frameworks I talked about has, NIST, CIS, SANS, any of these security exams or certifications, they're all getting to these same fundamental practices that your organization needs to have. Those are what's reasonable, because they are the industry standard. So you have to prove reasonableness to the jury, because again, and there aren't any lawyers in the room, are there? No? Okay, I would get in a lot of trouble for this really bad joke. But I almost put peers in quotes up here, a jury of our peers. The jury's not composed of people who do what we do, right? Your jury's going to be composed of folks who couldn't find an excuse to get out of jury duty in most cases. So they don't know anything about, there might be the one guy that does, right? He's an IT guy or an engineer, but generally the jury is completely ignorant of what we do in this field. So you have to educate the jury at the trial about what is reasonable. How are you going to do that? Well, you do it with evidence. In this case, expert witnesses are how I would do that. So what you're going to do is you're going to bring in some CISSP you found who's willing to take your money and sit on the bench or in the witness box for a while. And you're going to brag about his credentials, and they're going to sound real flashy to convince the jury that this guy's an expert and we should listen to what he says. And then you're going to ask said expert, what is the industry standard in this area? And what is anybody who would be qualified as an expert in cybersecurity, almost anybody, going to say? Right? It's those core fundamental controls you have under NIST, SANS, CIS, whatever. What you don't want is to be in the courtroom and have some expert witness who's very well qualified say whatever the industry standard is, and it's completely not what you were doing. That's going to end poorly. That's when your lawyer calls up the plaintiff and says, hey, let's re-talk about that settlement. So the moral of my story today, when we talk about navigating the minefield, the best thing you can do is don't be different. I know that we're all eccentric people. For some reason, our field just draws a very diverse crowd of people. We're all individualistic, but we shouldn't be professionally. Right? Listen to your security professionals and those basic things. If you perfect those critical security controls, whatever framework you want to go with, those foundational practices, there is not going to be an expert witness who's going to be able to say under oath, unless he's being paid a lot of money and doesn't care about his credentials, that you were being unreasonable or that you weren't acting in accordance with the industry standard. And when I say don't be different, one of my favorite examples of this is, you all know that NIST recently updated their guidance on password policies. Finally made official what most of us have known for a very long time, that the standard practice in password policies is at best neutral and not helping anything. Some people would argue that it's more harmful. And these talks have been going on for a long time. A lot of really brilliant people were making compelling mathematical cases for, hey, we should really be doing passwords this way. They might be right. But if their company did that before NIST, made it an industry standard, and then they're in the courtroom, and the jury, who doesn't understand any of this, is having, a tech expert witness tell them, this is how everyone does it, and they're doing something different, even if the different thing was maybe better, well, it's probably still not going to go well. I'm going to follow more on that for a moment because that's not always true. But use this, what we've talked about, use some of these buzzwords, right? Reasonable in particular. Your legal department will love you for that. Your compliance folks will probably have a hard time arguing too. If you're struggling to get budget for one of those core fundamental controls that you need, one of the better arguments you can have, especially if you're arguing with compliance or legal who want you to go do this checkbox thing over here to comply specifically with GDPR or something, and you don't have these fundamental controls in place, you can make a very compelling case that this is more important. Because if something bad happens under that, they're not going to focus on which box you didn't check under the minutia of the rule. A plaintiff's lawyer is going to zero in on those core practices because they're easy to go after. It's easy to find an expert to testify about what is reasonable security practices. So, like the minefield, when you navigate a minefield, I know we've got some military folks here, so you're going to know how this works. You don't just go and clear every mine out of it. Nobody's got time for that. You're trying to get to the other side. So you clear a safe path. This is the path you go along. So what I'm talking about today is doing that, right? You're not going to check every single box of all of that plethora of regulatory legal frameworks. What you're going to do is clear yourself a straight and clear path to the other side. May you suffer some financial penalty, maybe lose some smaller part of a lawsuit because you didn't check the right box under the CCPA that's not related to those core controls. Yeah, it could happen. Is it going to be anywhere near the magnitude of the expense you're going to suffer if you experience a data breach and somebody can prove that you didn't have those core security practices in place? No, it pales in comparison. So we'll focus on straight and narrow those core controls, and then let your legal department and your compliance folks worry about all the minutia. We as security professionals can go back to the way we were in 2005 and not actually care. Yeah, here, we'll check the box, leave us alone. We've got this core stuff, which is what matters. I did want to highlight some exceptions because technology is a constantly evolving art. One of my favorite cases from way back in law school that's always stuck with me is this thing about reasonable care. I just told you that reasonable care is what everybody else is doing, right? Follow the industry standard. Except when some new emerging technology pops up that's readily available, makes things better, but nobody's using it, you should probably still use it. So T.J. Hooper versus Northern Barge Corp was a 1932 case. It's very famous among law students because they all have to memorize it. Basically what happened where there were some tugboats, there was a storm that came through, some stuff was lost, and they were getting sued, saying, you should have known the storm was coming. It was broadcast on every weather radio out there. Tugboat owner said, we don't have weather radios. Nobody has those. That's not a thing we do. And they were right. And so they offered evidence in court to show that there's like one tugboat in the country that keeps a weather radio on board. But the court said, you know what? That's not good enough. And I've got this quote up here if you're interested in reading it. I'm not going to read it to you, but basically what the court said is the industry standard is not the only thing that defines reasonable. Right? An entire industry can be unreasonable. If you operate a tugboat moving large loads down waterways, and there's this now cheap, and not as cheap as they are today, but still cheap relatively, device that you can receive weather alerts and make everybody safer, you are breaching the standard of an ordinary person by not doing that. Even if nobody else is, you should still be doing it. So as new threats emerge in our world, right? So speculative threats were the big hot topic last year. If you run a data center and you're doing, co-hosting of a bunch of clients, maybe nobody out there is doing mitigation for those kind of threats. That's not going to be a defense if you end up getting sued under that. It's very likely that plaintiffs' lawyers are going to go back to this tugboat case and say, wait, this is readily available. You knew about it. You should have been doing it. And of course, let's go to the other side and say that you don't have an expectation to absolutely protect data. And this is the part where everyone nodding off, come back with me. Judge Learned Hand, if you've never heard of him, brilliant legal philosopher. Don't know why he was never on the Supreme Court. If you're interested in such things, he's a fascinating guy to read. But he authored the opinion in a case called United States versus Carroll Towing back in 1947. This is another one of those cases every law student gets beat over the head with their first year. And what this was a case of, again, with tugboats. Somehow tugboats set the basis that we use in cybersecurity today. It's weird. In this case, there were some tugboats that were left unmanned during the day, and some stuff happened. Long story short, the boats got loose. Nobody was on them. They're bouncing around the harbor, bumping into stuff, causing all kinds of damage. So the lawsuit followed, and there was this argument from the tugboat owners that, look, it's unrealistic for us to keep the boat manned during the day when nobody's doing it. Nobody else does this. It costs too much money. Judge Learned Hand agreed with them to a point. He said, you're right. You don't have a duty to go above and beyond what is reasonable. Now, he also found that the tugboat owners didn't meet that burden and they had to pay for all that lost grain. But he, in the process, laid down a formula which is still used in every tort action today that involves this kind of question. He created a formula of burden, so the burden you bear as a business, is equal to the cost of injury multiplied by the probability of that injury happening. Any CISSPs in here? Yeah, there's a bunch. You know, on the exam, that formula, risk equals impact times likelihood? Judge Learned Hand's where that all came from. They're teaching certified professionals to approach business this way. So if you have something that's likely, if it happens, to cost your organization $1 million, there's a 10% chance of it happening in any given year, then that's a $100,000 risk per year. And so any mitigation for that risk that costs more than $100,000 is beyond your organization's standard of care, right? That's unreasonable legally. And so one of the other defenses you can raise if you find yourself in the courtroom is, what the plaintiff's saying that I should have been doing unrealistic. I couldn't stay in business if I did that. And you'll note in the press when these data breaches happen, and you've heard that before, right? In the press conferences, from the spokespieces, from the entities that get breached. Like, look, doing this thing you're all saying we should have done would have put us out of business. Well, they're doing those talking points for a reason. This is setting up the defense for the lawsuit later. So, to circle it all back, those foundational controls, right? I got the Center for Internet Security stuff up here. You've all seen this, right? Tracking your inventory and assets, administrative privileges, vulnerability management, pen testing, all of this. These foundational principles, you'll also see it in the NIST cybersecurity framework. Looks very similar, right? And any framework you look at is going to follow along these lines. It seems like we are approaching the end of our time because Mickey told me I got a lot of time for closing ceremonies. So allow me to finally add a disclaimer. Because lawyers and we have to do these things. I am an attorney. I am not your nor your business's attorney. Everything I said here today does not constitute legal advice because, as you've seen, legal questions revolve around very fact-specific situations. Your business is in a unique spot from everyone else's, so some of the things I said may not apply to you. That being said, I've told you nothing today that I have not and would not tell my clients when they come to me asking, hey, what should I do? I've given you the same speech, roughly, that I would give them. The fact that they pay me may bear some judgment on their part, but there we are. So thanks again to the